We're live.
Hey there, everyone, and thank you so much for joining us for our weekly live class here on Tuesday at noon. We have a very special class today, but before I get into that, of course, as always, going to run through just a couple of brief announcements here before we get started. So just like this class, we do have weekly classes every Tuesday and Saturdays as well at 12 p.m. Central. So you can join us twice a week online here for these webinars. But we also have a networking happy hour. If you're looking for more of just, deals and service pitching, things like that, places where you can find some of your next investments maybe, the happy hour is a great place to do that. So that one's going to not have too much education, but just going to really be a place for you guys to network, make those connections, and really expand the people that you work with. So do be sure to join us for that one. That one's the fourth Wednesday at 6:30 of every month as well. If you do miss any of the classes, all of these that we stream online, these webinars, you can go back and watch those on our Facebook page, but also on our YouTube channel. Our YouTube channel is a great resource, not only for these pre-recorded classes that we've done in the past, but a lot of classes that we have recorded for you for tutorials, also ways to use, your client portal, some upcoming announcements and things like that. So be sure to go subscribe over there on our YouTube page. As I mentioned, we do have a lot of webinars, but we also have some in-person events as well. So this is a hybrid experience, but we really encourage you guys to come out, to come and network, and to really be in the classroom with us for the Self-Directed IRA Social. We do these every month, one in every office. Houston is the first Tuesday of the month, Austin the second, and Dallas is that third Tuesday. We do this one at 6:30. If you have come to the $1 trillion networking mixer in the past, it has a very, very similar setup to that event. But these are growing and growing in size every month. And next month, we actually have a very special one that I'm going to tell you about. And it is the Crypto Social. So if you haven't heard, we have brought crypto to Quest, and you can now use your self-directed IRA to do that type of investment. So we are going to have a very special social on April the 5th. It is our Houston social. So if you're joining us from any of our other cities besides Houston, we encourage you to come out, or like I said, you can join us online. But we are bringing out the CCO of ErisX, which is the platform that we're using to kind of do this cryptocurrency investing. And he's going to be teaching about how you can do this in your self-directed IRA. So that one's going to be a great class. We already have over 100 people registered to come in person, and that doesn't even include the people online. So you can scan this QR code, get your free RSVP, and join us for that social next month. So just a couple last slides here. We do have a Refer a Friend program going on. It's been going on, but we're just kind of revamping it, re-getting that word out there. But the way that this program works is if you know somebody that could benefit from having a self-directed IRA and you share the word with them, and they use your name, that's the key factor there, you guys will actually both get a credit towards their new account and your account as well. So you'll each get $25 added towards your account to help go towards maybe a transaction fee or something else like that. But that's a really great way to kind of incentivize you guys to share the word or, help get you guys some credits as well. The code that you would need to use is just your name. They'll use that whenever they fill out the application. And then the last slide that I have here, this is our Quest Expo. I know that you've heard us talking a lot about it, and that is because we have really geared up and we're getting so excited. Everything is really coming together. We have over 30 confirmed speakers and sponsors. They actually have some coupon codes. If you know any of them, they may get you one. Tickets are going fast, and we are just really getting excited for all the panels and the keynote topics that we are solidifying clarifying for you. Everything from real estate to notes to private entities, of course, but also some of those new things like crypto. We're bringing in more oil and gas and renewable energy resources. So a lot of great things for you guys here at the Quest Expo. Tickets are in early bird prices right now, so get them at the cheapest price. You can scan this QR code. It will take you directly to the website. And if you use my code, which is Shellam30, and I will type that in the chat box, that will get you an additional $30 off. So that's just for you guys for joining us. We wanted to say thank you. I will give that to you today during this class. So if you want to get in contact with us about anything else, about any of the events that I mentioned, or just how to get more information about self-directed IRAs, this is how you can do so. Feel free to scan this QR code. It'll take you directly to a Calendly link, which will let you schedule your direct consultation with an IRA specialist, or you can give us a call or shoot us an email. So I feel like I have chatted way too much. I will go ahead and pull my slides down and introduce our speaker today. But I have Taylor Ford with us, who's going to be sharing an interesting topic that whenever I actually saw it come across my screen, I was like, I would like to moderate for that one because I think I will learn something. But today it's going to be about how to complete a real estate purchase when the seller passes away or is deceased. So without further ado, I'm going to bring Taylor Ford of Doc Prep up here to teach today's class. Thank you so much.
Hi, everybody. Like she said, my name is Taylor Ford. I'm here with Doc Prep 911, and today we're going to talk about dead people. So what are we going to cover? We're going to cover underwriting requirements to ensure a sale when you have dead people on title, when your vested owners are deceased, or when they're legally incompetent. So we're going to cover both administrations, your dependent administrations, independent administrations, guardianships, and also intestate succession if these people are dying without a will. As questions do come up, please feel free to put them in the private chat so that we can kind of go and address them as we go through this. So let's go ahead and get started with administrations. So probate. I'm sure you guys have all heard this word, but what does it actually mean? It's actually Latin to prove or to test. So when you hear someone talking about was the will probated, that's literally what the process is. You take the will, it gets filed with the judge, they go and determine, hey, is this a valid will? Is anybody going to contest this? And then if so, it'll get admitted. But otherwise it would not. An administration, that's just a court action wherein a person is appointed to act on behalf of an estate in order to settle the debts and distribute assets. So if you're ever looking for where these records can be found, if you know that you're dealing with a seller that they tell you from the jump, hey guys, I'm selling my mom's house, she's deceased, we've opened up probate, and you can find those court records. Typically where you're going to be looking is in a probate court for the bigger counties, but in some of the smaller counties, it's going to be courts of concurrent jurisdiction, which are typically going to be your county courts. So depending on your county where you're looking for those, it's either going to be a separate probate court or it's going to be a court with concurrent jurisdiction, like a county court at law. So another fun thing that always likes to come up when you're dealing with these. You'll find out that, you'll have someone saying, hey, my mom died, but she left a will, so I'm going to go ahead and sell the house. Well, guys, if until that will is admitted to probate, it is not effective to pass title. So here's the section straight from the Estates Code, which basically says that, except as provided, a will is not effective to prove title to or the right to possession of any property disposed of by the will until the will is admitted to probate. Something to kind of keep in mind, because that people find the will, but they think it passes to it. But again, probate to prove, until it's admitted, you can't rely on it. Typically, whenever somebody dies, you have 4 years from the date of death to have that will admitted to probate. If it's later than that, you can still do immuniment of title, which we'll cover, but typically that has to be done within 4 years. So if you have a seller saying, hey, my dad died, they have a will, we're intending to file it for probate. If they died back in the 80s or 90s, it's probably going to be slightly more complicated than that. So some of the key terms you'll hear whenever somebody is discussing these, you'll hear someone throw out the word administrator, executor. And it's important to understand that these words are not interchangeable, although they are sometimes used interchangeably. So the key difference between an administrator and executor is how that person is appointed. If you are an executor or an executrix, that means you're appointed under a will. Typically, if the person died intestate, or if the person died intestate, that's where you're dealing with an administrator. So another key thing you'll hear, the title company will ask you, hey guys, so you've been appointed as administrator or executor. Can I go ahead and see a copy of the letters of administration or testamentary showing that you are actually have authority from the court to kind of go and act on behalf? So it's just, we'll look at an example here shortly, but all that is, it's just a one-page letter issued by a clerk, and it's evidence that the person named in the letter still has authority to act on behalf of the estate. So once that order admitting the will is signed, that same time, sometimes there'll be a swearing in, and the clerk will give you these letters of testamentary, which basically say that, hey, this will has been admitted. This person has authority to act on behalf of the estate. Here's an example of what one looks like. Again, it's very simple. It's by the county clerk, so it's not by the actual judge. The clerk is who does it. And if you ever need to get these updated for closing, it's $2 typically, and you can usually get them ready same day or the next day, so they're not overly complicated or complex to kind of go and get if you need to go get it for your closing. Because another thing you're going to learn as we kind of go through this is this one's dated May 8th, 2017. Typically, the underwriter is going to want that dated within 1 year of the closing date. So for something like this, they'd want you to go back to the court to get updated letters to show that you still have authority to act. You know, that you haven't been removed for cause, the estate hasn't been shut down, or anything of that nature. Another thing you'll hear about, the inventory. So an inventory is just a list of assets and liabilities of an estate. Why the title company, the underwriter, is looking for that is mainly due to they want to verify that this estate is not going to be a taxable estate. And by taxable estate, of course, we are referring to estate taxes. So I believe the threshold in 2021, it had to be $11 million. So basically, you're looking at that inventory to make sure that that estate is either A, not of that size, or B, if it is, there's enough assets there to cover any estate taxes should they be needed. And again, that's for P11. So the procedural rule 11 of the Texas Basic Manual, that's what deals with estate taxes. So that's why you need to go and look that up, because for the title company to be in compliance. Another thing you might hear. So sometimes you'll see somebody's both an executor under the will and a trustee under a testamentary trust. And all a testamentary trust is a trust created under a last will and testament. So depending on the will, sometimes your seller can be both an executor and a trustee of a testamentary trust. So here's kind of an example of what a balance sheet would look like. So sometimes you want to close before the inventory is ready, because the inventory, it takes a while to put together because you have to go and calculate all that information. Then you have to file with the court. The court then has a statutory period of whether or not they can approve it. If you want to close before then, in order for the title company to be in compliance with P11, another method is to provide what's called a balance sheet of the estate. And that balance sheet is just basically an informal inventory. And here's an example of one that somebody kind of did in the past. So it says it's an inventory and appraisement, but this wasn't actually filed in the court. And this basically just goes through for the estate to show here are the assets, the liabilities, and that's how you go and verify, okay, this is what the estate, the value is. So that's the way you know whether or not it's going to be a taxable estate. And here's another example of one that was actually filed with the court. Okay, so now let's talk about different types of administration. So as I alluded to earlier, there's going to be 3 different types we're going to cover. The first are independent administration. That term independent is important and distinctive in that an independent administration is conducted free of court supervision. So once you're appointed as administrator, and once you file that inventory, you can basically administer the estate free and clear of the court supervision. This is drastically different than a dependent administration. So a dependent administration is an estate that is fully administered under the supervision of the court. So the dependent administrator cannot distribute assets or act on behalf of the estate without court permission. There's actually a 4-step process that a dependent administrator needs to follow in order to sell property, which we're going to go over here in a little bit. The other type of administration you may run into is a guardianship. Now, there are 2 different types of guardianships. There's guardianships of someone's person and guardianships of someone's estate. So a guardian of someone's person can be their natural guardian, such as a parent, but a guardian of someone's estate is actually somebody who's appointed by the court, but who has the power to go and act on behalf of them. Again, we'll go over that a little bit later, but that's kind of the key distinction to keep in mind. So whenever you're dealing with real property, you must be dealing with the guardian of the estate. So not the guardian of the person, but guardian of the estate. Independent administrations. So if you have a seller who's an independent administrator or an executor, and you're trying to get all your documents in a row, so whenever you're submitting your contract or submitting your documents to the title company, what documents are you looking for to make sure that you have in hand, because that's what the title company is going to be asking. So the first one you're going to be looking for is that application of administration. That's the document that's filed with the court that basically kicks off the whole administration. You have the applicant who kind of goes and gives their standing. They talk a little bit about the person who's died, and they go and they ask for the type of administration being sought. Another document you're definitely going to need is the order appointing the administrator or the executor. So that's the document that once the will is admitted, or once the court is kind of approved that this person has authority, the statutory period for somebody to come back, and contest has expired, and this person is going to be appointed. Another thing you're going to need, of course, the current letters testamentary, which we went over. That's just the one-page letter from the county clerk, which says that the person acting as administrator or executor still has authority. Again, it's within 6 months or a year of your sale date. So those letters, they need to be updated within 12 months of the sales date. If the person died test date, you need a copy of that will. You need a copy of the filed inventory and the order approving inventory. Again, why do we care about the inventory? Federal estate taxes. Okay, switching gears now. So independent, get that, remember, they're going to be, once you are admitted and you file that inventory, that's basically it. After that, you're free to administer the assets, or distribute assets, administer the estate at your leisure. Dependent administration is going to be much, much different. So when your seller is a dependent administrator, you're going to need different documents in order to sell. So you're still going to need your application, your order, your current letters, but here's where it's different. To sell real property, the administrator first has to apply for court permission. So they actually have to file an application with the court requesting permission to sell real property. Once the court goes and looks at that application, they then approve it and say, yes, you're authorized to go and approve that property. Once that happens, that's typically when the administrator can go and contract for the sale of the property. Once they get that property under contract, they file what's called a report of sale with the court. It says, judge, court, you've given me authority to go and sell this property. I now get it under contract. Here are the terms of the contract. The judge wants to go and look at the contract and the HUD of the CD, because they basically want to go and make sure that selling this property at this price is in the best interest of the estate. Once the court has come to that determination that yes, it is in the best interest of the estate to sell that property under that contract, they'll enter what's called a decree confirming sale. The judge has 5 days after the report is filed to go and enter the decree confirming sale. So if you're wondering, hey, I filed my report, when can I expect to close? It probably won't be till at least 5 days after that. So guardianship. So that's a lot to throw at you. So I'm sorry if I'm going quick here. So independent, free and clear. Once you're admitted, you do the inventory. You can administer the estate at your leisure. Dependent. To sell real property, there's that 4-step process. For guardianship, remember, guardian of someone's person, the guardian of someone's estate, guardian of someone's person, they control over the person's personal matters, medical, education, living situation. They cannot sell property on behalf of their ward. These are typically going to be, your parents who are the natural guardians of their children. They have authority to kind of say, make medical decisions, where their kid's going to go to school, where they live, but that does not mean they can sell real property on their behalf. If you want to sell some real property on the behalf of somebody, you have to go to court and be appointed the guardian of the estate. The guardian of the estate to sell real property is a very similar process to the dependent administration. So you have that 4-step process, which is outlined in the parentheticals. You do your application, your order, your report, your decree confirming sale. So the guardian of someone's estate, this happens when your person has been declared legally incapacitated. So if they suffer some sort of cognitive dysfunction, which renders them unable to make legal decisions on their own behalf. So dementia, Alzheimer's, serious head injuries, things of this nature. So now that we kind of have had a brief crash course in administrations or independent, dependent, and guardianships, let's kind of apply some of the rules we just learned. So your seller signs your contract as the estate of Bob Jones. When you receive your commitment, title tells you that Bob bought the property as a single man. He died without a will, and he had 4 children, 2 of whom were born after 2010. Who will be your seller? So this is kind of meant to have a couple of red herrings and misleads here. So if you look at it, Bob owns the property. He died without a will. He had 4 children, 2 of whom were born after 2010. So, looking at this, your seller are going to be the 4 children. And since 2 of them are minors, your sellers are going to be your 2 adult children and the guardians of the estate for the minor children. Let's do another one because these are so much fun. The seller on your contract is the estate of Bob Jones. After reviewing title, you find that a dependent administration has been opened for Bob, and thus far, only the application and order have been filed and approved by the court. So what else do you still need before scheduling your closing? So remember, dependent administrations and guardianships is a 4-step process. You need your your application, your order, your report, and then your decree confirming. And a fun little bonus in here. How long does the court have after the report is filed to approve the sale? That's right, 5 days. So as you're kind of planning those out and you need to know logistically, how long should I know to project my closing day out? It should be at least 5 days after the report because it'll take at least that long for the court to kind of go and either approve or deny the sale. Let's do another one. Your seller under contract is again Bob Jones. After opening title, you learn that Bob died in 1984, but had a will admitted as a muniment of title in a county other than where your property is located. Who will be your seller and what will the underwriter typically require regarding Bob's estate? So a muniment of title, all that means is that instead of having somebody appointed to act on behalf of Bob's estate, the will was admitted to pass title only. So because of that, there's no executor who could sell the property, but title still passes pursuant to it. So your seller will be the devisees under the will. And since the will was administered in a county other than where the property is located, you're going to have to record some certified copies, specifically the order and the will and the real property records in the county where the property is located in order to update the real property records as to the passage of title. All right, let's do 2 more of these. Your seller under contract is again Bob Jones. When the seller turned in the contract, they included a copy of the letters of administration, and in reviewing the estate, you see that the will grants the executor the power of sale. The executor has already filed an inventory which has been approved by the court. What else do you typically need before scheduling your closing? So this one's kind of a tricky one. Typically nothing. If you have all those ducks in a row, you're in great shape to kind of go ahead and get your schedule for closing. Because you already have your letters, the inventory is taken care of. So you know that you have somebody who has authority to act on behalf of the estate. They've already addressed whether it's taxable, so you should be good to go. And last one before we move on, your seller under contract is again Bob Jones. After speaking with the seller, you learn June Jones is offering title as the guardian of Bob's person. What all must you request from June before you schedule your closing? So if you read through the question, it says June is offering title as the guardian of his person. As we talked about, unfortunately, the guardian of someone's person does not have authority to sell real property on behalf of their ward. If June wants to sell real property on behalf of Bob, she's going to be appointed the guardian of his estate and go through the 4-step process we outlined earlier: your application, your order, your report, and your decree confirming. Okay, so now let's change gears. We've talked about administration. Administration is when you're dealing with a court, so that you have a will or they filed some sort of court action to kind of go and determine who has authority to act on behalf of the deceased party or the incapacitated party. So what happens if you don't have a will or you don't have an administration? How is title determined, and what should you be looking for in order to get your contracts ready to make sure that you're going to be ready to get to closing? So let's start with the word intestate. The word intestate literally translates to without a will. So in legal terms, it literally translates, it means you have died without a valid will. The phrase intestate succession. So sometimes you'll hear that. You'll see it up here at the top of the slide. Intestate succession refers to the codified distribution of assets for a decedent who dies without a will, which can be found in Texas Estates Code 101. So the legislator basically got together and said, hey guys, we're going to go ahead and outline what happens to your property whenever you die if you don't die without a will. So they go through and they do an order of descent and distribution. So in order to understand the descent and distribution, you have to understand a few legal concepts. So the first one you have to kind of understand, get in your head, is the inception of title. Inception of title is basically talking about how was the property acquired, because a property's character is determined on the manner and time in which a person acquires the title. So for our purposes, that basically means that how you acquire the property determines how intestate succession and other rules are going to apply. So there's two different kinds of characters of title in Texas. So Texas is a community property state. So the first one's community property. Community property is property acquired during the marriage. In Texas, any property you acquire during the marriage is presumed to be community property. This is, of course, a rebuttable presumption, but that's how it works. Anything you acquire, we're going to presume is community property. Separate property is going to be property that's either A, acquired before the marriage, so when you're single, or it's going to be your inherited property, because inherited property is separate property. So now that we kind of have those two things in mind, so remember, inception of title, whenever the person acquired the interest in the title, or excuse me, the interest in the property, did they acquire a community interest or a separate property interest? So the typical order for descent and distribution of community property is at the top of the order. The first person to get that bite at the apple is going to be your spouse. If a fun little rule, if the decedent died prior to September 1st, 1993, the community property interest does not pass automatically to the spouse. Instead, it automatically passes to the children. So sometimes when you're dealing with these files, when you have people, a couple generations of family and title, and you find out that some of the predecessors died many, many years ago, and they think that everything went to mom, they'll find out, well, actually, no, everything did not go to mom, because when dad died, his interest automatically went to the children. So that's how the children are automatically entitled. So even if the mom dies and leaves a will, the children received an interest under the father, and they're going to be required parties. After the spouse will be the children of the descendants. After that are going to be your parents, which always surprises people. So spouse, children, parents, siblings. So if you don't leave a surviving spouse, so you die in a common accident or your spouse predeceases you, you do not have any descendants or descendants of your child's descendants, so any grandchildren. You're predeceased by both parents. You do not have any living siblings or siblings descendants. What they do is they divide your interest into two moieties. So they basically start with your maternal grandparents and your paternal grandparents, and it's kind of divided out down the road between aunts, uncles, and cousins. If you ever find yourself dealing with one of those files, you never forget it, because typically they are going to be a little bit of a headache. Now, it's surmountable, but it's going to be more work than normal, because you're going to have to do pretty much a full family tree to find out, okay, who actually inherited their interest. So this changes when the property is separate property. So remember, we talked about inception of title. So what happens if the person who acquired the property inherited the property inherited the property or acquired it prior to their marriage? So the spouse will still get the first bite of the apple. However, if they only get a 1/3 life estate in the property. So they don't get a full interest. They don't get an interest that they can pass on. They don't get an interest that's going to survive once they die, but they get a 1/3 life estate. After that, it goes to your children, again, your parents, your siblings, and your paternal and maternal kids. So it's children and grandchildren. So if you have any children who are deceased, their interest goes to the grandchildren. And then siblings, same thing. If your siblings are deceased, it'll go to their descendants. And then if none of those people are around, that's when we have to go back, paternal grandparents, and start working our way down. So here's a fun little handy chart that kind of helps visualize how that's done. So this chart, which will be available in the slides, which I believe Quest will make available through the video, kind of shows you a quick review into who's going to get what when dealing with property. So you'll see you have your separate property, all other property, and kind of who goes and gets what. All right, so now we have about 10 intestate problems to kind of go over to kind of hit home the things we discussed. So the first one, Bob and Betty buy Blackacre as a married couple in 1954. Bob dies in a tragic chainsaw juggling accident, he should have known better, in July of 93 without leaving a valid will. Bob has 12 children. All of his marriage to Betty. Who is going to be your seller? So let's think this through. So we know it's community property under Inception of Title because Bob and Betty buy together as a married couple in 1954. Bob dies in July of 93, which is before that magic date of September 1st, 1993. So because of his death before September 1st, 1993, your seller are going to be Betty because she retains her 1/2 interest. Excuse me. And then all 12 children. Because Bob died before September 1st, 1993, his community property interest does not go to Betty. It goes directly to his children. So that's how they all get on there. Let's do another one because these are so fun. Bob and Betty buy Blackacre in 2003. Bob and Betty die in a freak gasoline fight accident in 2017 without leaving a valid will. So again, Bob and Betty, Blackacre, Inception of Title. They have community property. They die in a contemporaneous accident. So they both die in 2017. They have one child named Fred who is married to Fredina because if you a guy named Fred, you meet a woman named Fredina, why wouldn't you marry her? They both live on the property and it is considered their homestead. So who will be your seller? So we know under intestate succession that the property is most likely going to go to Fred because Bob and Betty die. So remember, it goes spouse and children. So Fred's going to be our seller. But because Fred and Fredina both occupy and reside on the property as their principal homestead, a fun little provision of the Texas Family Code is going to apply, which basically states that regardless of whether the property is separate property of either spouse or the community property of both spouses, neither spouse may sell, encumber, or convey the homestead without the joinder of the other spouse. So even though we can show here that, hey guys, Inception of Title, this is inherited property, it's Fred's separate property, his wife is still going to be required property because it is the family homestead. That's something that comes up a lot. It surprises people. They try to do non-homestead affidavits, but unfortunately that won't work. If it is the marital homestead, she is going to be required signatory and party to your sale. Number 3, Bob and Betty buy Blackacre in 2012. Betty dies in 2013 and Bob dies in 2015, both without a valid will. Betty has 2 children outside the marriage, Greg and George. Both are married, but they own and occupy other property as their homestead. Bob has 1 child, Heather, who is single. So based on this, who do we think our sellers are going to be? If you think it's going to be the children of Bob and Betty, you are exactly right. So Betty has her 2 children. So Betty's interest would pass to Greg and George, and Bob's will pass to Heather. So your sellers will end up being the 3 children. So even though they may have different interests, those are going to be the children. Those are going to be your required parties to your contract and to your sale. Number 4, Bob buys Blackacre in 1975. So Inception of Title, Bob buys it. It's a separate property. Bob later marries Betty in 1982. Betty dies in 1988 without leaving a will. Betty has 4 children from outside the marriage: Alfred, Beatrice, Charles, and Delilah. All 4 children are married, but all own and occupy other property as their homestead. Who will be your seller? This is a fun little tricky question. So let's work it through. So Bob buys it in 1975, so we know it's Bob's sole and separate property. Bob later marries Betty in 1982. Does Betty have a valid interest in, does Betty have a vested interest in the property which could pass to her children, her 4 children? More than likely, no. Her estate maybe have a claim to the property for some sort of community property restitution. If her estate made contributions to the property over the lifetime, paying down the mortgage, repairing the property, things of that nature. But other than that, She didn't have a vested interest in the property, which would then pass to her children. So once she dies, more than likely, Bob is going to be your only seller. Again, fun way. That's why Inception Title is so important, because just because they got married doesn't make it Betty's property. Number 5, Bob and Betty buy Blackacre in 1954. So we have a buying it together. It's going to be community property. They divorce in 1965, and the property is awarded to Betty. So it starts as community property in 1965. That community property is changed and becomes Betty's separate property. So Betty then marries Charles in 1966. Betty dies in 2008 without leaving a valid will. Betty has 2 children, Mark and Mork, who are both single. Who will be your seller? So let's think about this. So we know the property started as community property, but it became Betty's separate property pursuant to the divorce of 1965. Betty marries Charles in 1966, but at that point, it's still her separate property. So when she dies in 2008, it's still her separate property. So Mark and Mork are going to be your sellers, but remember, even though it's her separate property, Charles still gets that 1/3 life estate in her separate property and his potential homestead rights. So your seller, even though, but Charles is invested because he is a surviving spouse, he gets a 1/3 life estate in her separate property. So he would be a required signatory to your sale. Okay, we got 4 more of these. So Betty buys Blackacre in 2000. She dies intestate in 2003. She was never married and had 3 children, Charles, Delilah, and Edward. Charles predeceases his mother in 1998. He was married to Charlie and had 2 children, Charles II and Charles III. Delilah dies intestate in 2005 and was never married and never had any children. Edward is living in the property with his spouse, Edwardina. Who is going to be your seller? So, strange names aside, let's kind of work this through. So we know it's Betty's property. She was never married, so there's no surviving spouse. So it's going to go to her 3 children. So we have it divided up into 3 sections. We have Charles' interest. So Charles predeceased his mother. So his interest is going to go to his 2 children, who are Charles II and Charles III. Then we have Delilah. Delilah dies intestate, never married, never have children. So because of that, her interest is absorbed by her 2 siblings, Charles and Edward. So Edward, we know Edward receives an interest, and because he lives with his spouse, Edwardina, they're both going to be required parties. So Edward, because he inherited an interest, and then Edwardina, because it's her homestead, and Edward can't sell it without her joinder. I know, fun stuff. All right, number 7. Bob runs away from home at age 15, but is somehow able to not only qualify for a mortgage, but also purchase Blackacre in 2003. Bob dies tragically from a sugar overdose in 2004 without leaving a valid will. Bob was never married and never had any children, but both of his parents and all 3 siblings survive him. So who will be your seller? So let's think about this. So Bob buys a property, not married, so it's his sole and separate property in 2003. He dies, so let's go through our order. So the first bite of the apple would be the spouse. There is no spouse. Second are going to be children. There are no children. Next on the list are going to be parents. So even though Bob has siblings, the parents get the first bite of the apple. So because both of Bob's parents survive him, they will inherit his interest in the property, and they will be your sellers. Okay, 3 more. Bob buys Blackacre in 2004. Bob dies intestate in 2006. Bob was never married, never had any children, predeceased by both parents, and does not have any siblings. So who will be your seller? Okay, so let's think back to our list. So spouse, children, parents, siblings, and then the 2 moieties. So your paternal and your maternal kindred. So basically you go up to the grandparents and you start building out a full family tree, and all the aunts, uncles, cousins will be the people who will be your required parties, because they will be the ones who inherits the interest. Again, these files are going to be your very fun files, because typically when you're dealing with this, you're going to be dealing with many, many people. And dealing with many, many people Logistics are always fun. All right, two more. Bob and Betty buy Blackacre in 1965. So Bob and Betty, 65, community property. Bob dies with a valid will, which leaves everything to Betty in 1969, and Bob's will is admitted to probate. So that we know that as of 1969, everything becomes Betty's separate property. Betty then marries Charlie in 1975. Betty and Charlie have lived in Charlie's house since marriage and occupy it as their marital homestead. So when Betty goes to sell Blackacre, who are going to be your sellers? So let's think this through. So we know in 1969, the property is Betty's separate property. She's married, but since it's her sole and separate property, and since it's not her homestead, our only seller is going to be Betty. Underwriting or the title company is likely going to require Charlie to sign a non-homestead affidavit, waiving his homestead rights and designating the other property as their homestead. But other than that, he most likely will not have to be a party to your sale. If he's asserted an interest in the property through signing some sort of deeds of trust or other things of that nature, maybe that changes. But if not, more than likely, Betty should be able to sell it without Charlie, other than having him sign a non-homestead affidavit. Okay, last one. I know you guys are bummed because these are so much fun. So Bob buys Blackacre in 1984. Bob was never married, but he has 6 children. Bob dies testate in 2004. His will, which was admitted to probate in 2007, bequeaths everything to his favorite child, George. George's siblings execute and record an affidavit of heirship and execute a contract to sell real property. Who should be your seller for Blackacre? So if you are a real estate investor who is adept at finding distressed properties due to deaths in the family, this situation is more than likely something you've dealt with in the past. You'll have family members who think that they inherit a property because someone died and they're his kids, so they should have a right. So they'll go and file an affidavit of heirship thinking that that's going to control over a will. The takeaway from that is no. An affidavit of heirship does not control over a will. If you go through the trouble of going to court, getting that will admitted, and doing an administration of the estate, that will control over the affidavit of heirship. So in that case, the underwriter may have some requirements to kind of go and make sure that nobody's going to file a lawsuit or try to go back and contest the will if they're still within that statute of limitations. But other than that, your seller is going to be George, because Bob went through the steps of not only executing a will, but making sure that it was left with somebody who was able to then go file it, have it made to probate, so that his last wills and wishes that the property goes to his favorite child, George, and not the other other 5 children, was fulfilled. So now that George will be your only seller. All right, everybody. That's everything I had for you on administrations and intestate succession. Hopefully I didn't get to go too fast and you were able to get a lot of good information out of that. If you have any questions, you should be able to get my contact information from Quest, and I look forward to hearing from you.
Awesome. Thank you so much. Yeah, it looks like we don't have any questions at this time, but if you wouldn't mind posting your contact information, I'll go ahead and pull it up on the screen, or if you would just want to say it out loud, I can type it here as well.
Sure. So it's Taylor Ford, and my email is going to be TAYLOR, and that's at DOC, prep, PREP, 911.com.
Perfect. Yep. So here, this is for you guys. If you want to get more information, feel free, shoot them over an email. But thank you so much for joining us. We have the class pre-recorded, so if y'all want to go back and watch it, that will be available as well. Well, yeah, that's all for our class today. So looks like, yep, no comments quite yet. So I think we'll go ahead and round it out. So thank you so much.
Thanks, everybody.